If we haven't met before, I'm Sarah, an end-of-life planning advocate, normalizing conversations about end-of-life and estate planning before those conversations are necessary. Hopefully you have, or soon will have, completed all of those estate planning documents and jumped through all of the legal hoops to make them official, because after a death, fixing the mistakes of an improperly executed will can be expensive and time-consuming. All too often, those mistakes can't be fixed at all. The same handful of mistakes are seen time and time again. Luckily, many of those mistakes are easily prevented. Estate planning mistake number 1, not doing any estate planning at all. There are countless reasons people do not do any estate planning. They don't realize they have to, assuming their estate will just take care of itself. Confusion about what's involved or where to start. Not being willing to consider their mortality or not wanting to have to make difficult decisions. But not making an estate plan doesn't mean that no one will ever have to make those difficult decisions. It just ensures that your people will have to do it while simultaneously ensuring that they won't have the information that they'll need to make those decisions. And if you don't make an estate plan, you might end up with someone you wouldn't choose for yourself, making decisions about you or your stuff or getting your stuff. There are processes in place for determining who can act on behalf of someone who has died or become incapacitated. The rules vary by state, but are always some version of determining your nearest blood relative or your spouse. The rules are imperfect and not what most people would choose for themselves, especially if you are surrounded by friends, chosen family, or a committed but unmarried partner. To prevent this mistake, do the paperwork. Everyone 18 and older should do some estate planning. What that looks like and what it entails will vary significantly. The estate plans of a single 20-something and the estate plans of a wealthy couple in their 70s will look very different, but are equally important in their own ways. Document who should get your stuff in a will. Document your healthcare wishes and appoint a healthcare agent in an advanced care directive or a living will. Then ensure everything is witnessed or notarized as required by your state to ensure it's all nice and legal. Estate planning mistake number 2, not reviewing or updating your estate plan. Things change and your estate and end-of-life plans might have to change too. Even the most once upon a time perfectly executed will can create chaos if it isn't updated after a divorce or a remarriage. To prevent this mistake, review and update as needed your estate planning documents regularly, especially after a major life event like a birth, a death, and the marriage. I've always heard that you should review your estate planning documents at the 5 Ds: decade, divorce, death, diagnosis, or decline in health. Estate planning mistake number 3, not discussing what's in your estate plan. I get it. Conversations about your death or your potential incapacitation are awkward at best. But avoiding the conversations doesn't make the problems go away. It just ensures your people won't have the necessary information to deal with whatever happens if you're incapacitated or after you die. To prevent this mistake, talk to your people about your plans, what you want, and where your documents and information are kept. Have conversations about your wishes for medical care in case you're incapacitated, your wishes for your body's disposition and funeral, what's in your estate planning documents and where they can be found, where you keep important documents and information about your passwords, accounts, and other key information. Estate planning mistake number 4, making your stuff impossible to find. How and where to store important estate documents as well as other documents like passports and birth certificates and supporting information like bank account numbers and passwords can be a tricky balance. It contains tons of personal information that's kind of the point, so it must be kept in a safe and secure place, but not so safe and secure that your people can't find it or can't access it when they need it. For example, you can keep your will in your safe deposit box and it will be nice and safe, but your people might not be able to access your safe deposit box after you die. To prevent this mistake, make sure your people know where to find your important information and important documents, and make sure that a trusted person will be able to access that information when it's needed. Estate planning mistake number 5, not considering your digital life. Your estate plan likely considers your house and your bank accounts and your other in real life stuff. Having a digital or online life is a fairly new concept, and many estate planning resources haven't caught up yet. A major area of our lives where your estate plan might be lacking is in considering your digital estate. What are your email addresses and passwords? What messaging apps do you use? What online services do you subscribe to that will have to be canceled? What apps do you use for note-taking, photo storage, and video storage? What do you want done with your social media accounts? Can you imagine someone having to wrap up your affairs without having access to your digital life, especially something like email? To prevent this mistake, consider your digital life when creating your estate plan. Make plans for what you want to have happen to your digital assets after you die, and ensure that someone will be able to access those digital assets. Document your digital accounts and services, as well as your usernames and passwords for those services. Auto renew and auto billing services are super convenient while you're alive, but those services will continue long after you die unless and until somebody knows to cancel them. They'll only know they have to cancel them if you've written down what those services are. Estate planning mistake number 6, not following the documentation rules. The worst time to figure out that mom didn't cross all the T's in her will is after her death, when very little, if anything, can be done to fix it. DIY tools can be a great option, but there's a reason estate lawyers and financial planners exist. The rules can be complicated, counterintuitive, or archaic, and the rules vary by state and by document. Usually, documents like wills and advanced care directives need to be signed by you and either notarized or witnessed. Often there is a list of rules about who those witnesses can and cannot be. Those witness requirements are not suggestions, they are requirements. Probate courts are not known for looking at an improperly executed will and saying, meh, close enough. If you do not jump through the right hoops, your will not be valid. To prevent this mistake, consider hiring a professional and make sure you follow all of the rules to the letter. Sure, it's annoying to have to get a form notarized or to make sure all of the people signing your document as witnesses qualify to be witnesses, but not following the rules could result in the document being deemed invalid and being thrown out. If you found this video helpful, hit that like button and also consider hitting the subscribe button for regular end-of-life and estate planning information.